Welcome at this third edition of the HR Quarterly Updates. Welcome. This edition is with my colleague Alain Caminier and my name is Nikki de Groot. This time we discuss with you several topics. But first I want to highlight the next edition, and that's the 2nd of December. The same thing, the last one of the year. And now I go over to the topics we will discuss right now. And the first one is AI and employment. My colleague Alain Caminier will discuss several employment topics or issues with AI or solutions. Then I will discuss briefly the basics of instant dismissal, and I will also discuss some case law. You can ask some questions during the presentation, during this webinar, but also at the end of this webinar. We will take a look at your questions and hopefully we can answer them right away. Of course, we have also some poll questions. Please give your answer real quick, and we will discuss also the answers a little bit and discuss them further. We would like to know what is your practice like? Are these topics relevant to you? And at the very end of this presentation, there will be a webinar evaluation. Let's kick this off. I will give the floor to Alain Caminier, who will discuss AI and employment. The floor is yours.
Thank you, Nikki. Thank you for the remote. AI. Yeah, nobody doesn't know what AI is at the moment, I guess. And everybody I know has in some manner used AI. The question is, what does AI say about the employment working floor, and what does that mean for employers and for HR professionals and lawyers? When we talk about AI in the workplace, we can talk about a lot of things. We can talk about the restrictions coming from Europe, the AI Act. We can talk about AI and equal treatment, discriminatory law. We can talk about privacy and AI. We can talk about AI and employment conditions. We can talk about AI and works councils, AI and termination of employment contracts. But we don't have time to address every issue. So I've taken the most important ones for today, talking about AI in the workplace. First of all, a poll question for you. Do you allow within your own company AI tools in the workplace? How can people work with ChatGPT, with Perplexity, with Claude, with the Copilot, whatever, or maybe even other AI tools in the workplace? So, while we'll wait, Nikki, do you use AI in the workplace with Pallas lawyers?
Yes, we do. Of course, there are some restrictions, and of course, you cannot share everything with the AI tools, but it's very useful, and work can be done quick. I can use it for different services, so to say. So give me an overview of this, translations. I think is very useful. Of course, there are some risks, and I'm sure you will discuss it. And I would like to know also what people use in practice and for what purposes.
Yeah, I can imagine. So I think I can click for the next slide.
Sure.
Yeah. So let's start with the European AI Act. So there is since August 2024, so already 1 year, there's an AI regulation which comes from Europe, a little bit the same as the GDPR regulation, which we all know with respect to privacy. The AI regulation gives all kinds of obligations for deployers of AI, what you can do and especially what you can't do. And this act is implemented in Europe, so it is in force for each European Union member state, the 27 EU members, and they have direct effect. So you can refer to the AI regulation, and I simply will call it the AI Act as from now. What does this AI Act say? It says a lot about technical issues with respect to AI. So, for example, if you are a developer and you want to create a chat box based on AI, there are also rules and restrictions you should take notice of. But that goes a little bit too far for my presentation. And by the way, I'm a simple employment lawyer, so I will only talk about AI on the work floor. So when we see what is in the AI Act with respect to HR issues, then there are two things very important to realize. The AI Act classifies all AI issues in risk classifications, and we have 4 classifications. That is an unacceptable risk, a high risk, middle risk, or limited risk. And you can see this is mentioned in Article 6 of the AI Act. It's on the sheet. Be aware that every HR issue based on AI, so every AI risk which deals with HR is classified as high risk under the AI Act. So you must take into consideration that this is a high risk classification. And what do you have to think about? Recruitment, in the case of application for a job, selection, who do we want to do something or we don't want to do something, evaluations, promotions or terminations based on AI, all high risk, and you should deal with that as mentioned in the AI Act. So, what are then risks? When we talk about high risks, when the AI Act was set up in Europe and it was discussed within the European Parliament and within the European Commission, then it was clearly stated, and also we realized that AI can violate fundamental rights for employees, such as privacy rights, non-discrimination rights, freedom of speech rights, freedom of expression, and that is something that you should take good care of when you are an employer. And again, I will only talk about AI on the work floor. But to give you an example, what can go wrong when we talk about non-discrimination, I would like to refer to the child benefit scandal, the toeslagaffaire in Dutch, which is a big issue in the Netherlands, where based on algorithms, which is AI, without any human oversight, people were accused of fraud, got into prison, and all kinds of other problems, to deal with large debts, problems with a child being placed outside of the family, a big issue, but that is a risk which is taken into consideration with the AI Act. Then we say, hey, but maybe the child benefit scandal, was that already AI? Yes, it was. The public came in touch with AI, I think from 2022, where ChatGPT was introduced within everybody's environment, so to say. But be aware that already long before that, AI was available for corporates, for governments, and they used it quite a lot. We talk about algorithms, we talk about machine learning, that is all AI. If you order an Uber, for example, or you order a meal, from a platform all AI based. So we use it quite a lot already. With respect to employers, because that is what we're talking about, the employers are obliged to take technical and organizational measures when you use AI. So you can't simply say we hire a company and that company is going to introduce AI within our company. You should be in the loop as company. There should always be a human in the loop. So if you ask AI to do something, you can't send it out outside the company or inside the company where employees are affected. There should always be, as we call it, a human in the loop who must be the ultimate responsible for the AI tool. The human in the loop should have training and should be authorized. That means that the one who is responsible for the use of AI and the results of AI should know what he or she is doing. So he should be adequately trained, and he should also have the authority to stop the AI tool or to stop the consequence of the AI, and that is explicitly mentioned in the AI Act. Everybody who uses AI and is using a tool which is brought to the employee by the employer, so the employer bought an AI tool or allows an AI tool to be used, the employer should train the employee in, so it's called AI literacy. And that means that you should simply send your employees on a course if you let them use AI on the work floor. In Dutch that's being called AI geletterdheid, and that is a term introduced by the AI Act, Article 4. If you want to know more about that, I also mentioned a link with the Privacy Authority, because we do not have an AI authority yet in the Netherlands. So the authority from government who checks and monitors AI use in the Netherlands is the same as the authority who checks the GDPR and the privacy laws, which is the Autoriteit Persoonsgegevens, the Privacy Authority in the Netherlands. And they have a lot of publications based on the AI consequences and risks. So if you go to the AP, that is, I think, a good thing if you have not done that yet as employer. So specialized training courses, you should think of that, comes directly as an obligation from the AI Act. And Article 26 also says that, if you do more and more with AI, you should more or less appoint an AI officer. A little bit the same like you have the data privacy officer if you are a company with more or with 100 or more employees. That is not so specific in the AI compared to the GDPR, but that is very well recommended. If you use AI as an employer and you push data into the AI tool, the data must be relevant and representative. That means that you can't put a data dump, you take your data from somewhere and just throw it in the tool. You must be able to tell at the end what you put in the AI tool and why you put it in there. And that is very important if you don't want to come to penalties or damage claims. So you should always be responsible and liable for your own data and your own tool. Employers must also continue to monitor the AI tool and AI itself, and also the output, so the risk with respect to AI that should be continuously monitored and looked after and changed if necessary. And again, you should also be able to intervene with the AI tool if it doesn't work correctly. And you, for this reason, you are also obliged to keep logs. So there should be a logbook for at least 6 months in which you can state what the AI tool did and did not with the data. Little bit the same as with the GDPR. There is an authority, and again, that's the same authority at the moment, as with which also takes and monitors the privacy data within companies, the authority, the Data Privacy Authority. There's also supervision by the Dutch Digital Infrastructure Inspectorate, the RDI, and the idea is that RDI and the AP together will form a new authority to oversee AI within a couple of months, hopefully. If you do not follow the AI Act at that stage and someone files a complaint, and someone that could be everybody, more or less, you could be fined by the AP up to 15 million euros or 3% of the global turnover of the company. And I can tell you that's a little bit more than the fines mentioned in the GDPR, because that is 10 million or 2% of the global annual turnover. And this is about normal fines. You have also higher penalties, higher fines if you deliberately and heavily violate the AI Act. But most companies will have to face the risk of this fine. And of course, there's always a discussion possible about do we need to put up this fine, or should it be less, or whatever? And we don't know at the moment, of course, how many fines the AP will give to companies and how high that fines will be. But this is in the AI Act at the moment. I'm not aware of any fines already been given to companies or governmental organizations yet. When we talk about the AI Act, the points of criticism are also there, because AI comes and goes in a high pace. So what about this AI Act, this AI regulation? There are some open ends, so that is not that clear always what you should do and not do. There's a risk of becoming a paper tiger. Those fines, will those be placed into practice or not? And everybody is waiting for further guidance from EU, and that is coming up. So be aware that things might change. So when one of the issues, non-discrimination, is important with respect to AI. An issue is that AI can at one time reduce bias, but it is also biased more or less, because AI is created in the Western world. We know that AI takes the position of white people as a norm, and not so much diversity. So it is already biased as such, and you should take that into consideration. Everything you put in comes out. So if you have your own AI tool, garbage in is garbage out. So that can also create all kinds of issues. And you cannot let transparency in or non-transparency in algorithms be the norm. You should be able to explain what is going on. So I'll give you some examples of what could be the problem with AI and discrimination. And again, AI already exists for a number of years within the case law. The VU, that is the Free University in Amsterdam, it used software to identify people if they had to make an exam online. And there was this student who had a dark skin who could not do the exam because she was continuously denied access of the exam. And she stated that that had to do with her dark skin and that created a suspicion of discrimination. At the end, there was a full procedure with the authority of human rights in the Netherlands, College voor de Rechten van de Mens. And at the end, the authority said, yeah, we don't see real discrimination here, but that could have been different if the university could not have explained completely what the AI tool did, but they had to change the AI tool to not let that happen again, but it was not being seen as discrimination. Amazon, maybe everybody knows this example, and I refer to a press publication in a Dutch newspaper where Amazon looked at their most successful employees, and they said, with respect to our new recruitment and our new AI recruitment tool, we want to that you AI that you select people who are most successful in our company. And then that tool selected only male applicants, which was definitely a discriminatory tool in that perspective, because the algorithm simply favored male applicants. And again, I already referred to the child benefits scandal, the toeslagenaffaire in Dutch, so I'll skip this for now. With respect to another poll question, is staff required in your company to use a corporate account like ChatGPT Enterprise or ChatGPT Team, or can they use their own private accounts when doing work for your company? So is it yes or is it no? So Nikki, corporate accounts. We have within Pallas, we have a corporate account. What do you think of that instead of using your own account?
I think it's very useful. Number one, you can easily log things. Before you said, okay, you have to log things. If you have your own account, it's very hardly impossible to log as an outsider. Also, the security of your information. Do you put all your information, your confidential information, do you share that with AI tools, or do you need some more protection? And I guess, the corporate accounts could give you some protection that at least your own information is not shared with the AI data.
I agree. So the corporate accounts, they say, and we don't know what those big tech companies do, but they say we do not train with information you provide us with in the corporate accounts. So that's a good thing, but be careful. Don't put privacy data in ChatGPT or any AI tool. And whether or not you have a corporate account, be very cautious what you do, because nobody really knows what AI is doing with your data. So, going to termination of employment contracts, and that is what we see quite a lot. The A ground, as we call it, then we talk about grounds for termination based on business economics or business organizational reasons. Those are reasons to reorganize your company and to make people redundant. We have that already for decades here in the Netherlands and everywhere else, by the way. So if you say, hey, where does AI fall into? AI may fall under organizational reasons for termination. We're going to reorganize our company or our team making use of AI, and then it's really out in the open that AI is a reason for redundancy. Technical changes, the same. We have an AI tool and it will take over some work. We don't see the latter one quite often. Most of the time it's more or less embedded in business organizational reasons, where they say, for example, there are people who couldn't do this function before, but with AI they are more competent to do this kind of work, and therefore we don't need the work in a function below, or some issues concerned. But that is being used as a reason for termination. Be aware that as an employer, based on the AI Act, you must demonstrate that the job which is being made redundant is structurally and efficiently redundant. And it is not so simple there. If you use AI for a task, that definitely makes a position redundant. That is not how it works. So you can't simply replace a function for AI. You should really create a description why this job will be fully taken over by AI, and very simple, because AI can also lead to new tasks and new positions. Simply because I have an example here of a radiologist. There are other tasks like patient contact, plans, treatment plans, team consultations. They remain necessary and should be redeveloped for such cases. And AI also will create new tasks, for example, coming from the AI Act, such as monitoring. So, last but not least, we of course can also talk about AI and other grounds for dismissal, and other grounds under Dutch law could be disperformance, culpable behavior, and disrupted relations. I would simply end with 3 examples. ABN AMRO, the bank in the Netherlands, they had for traders, they had a system where if someone who was doing the trade on the stock market for clients, and he went a little bit too far from the risk analysis, then he got a warning based on AI, machine learning warning. Hey, be careful, you're taking too much risk. And if that pop-up came onto the screen 3 times, at that stage there was a team coming, people from the people team came to see whether the AI tool was doing its work correctly, so it was not in defect or so or not, and that happened. 1 warning, 2 warning, 3 warnings. The team came in, so that's the human in the loop, and at that stage this person was dismissed on the spot. The cantonal court in the Netherlands said, yeah, we don't know what this system is doing, this AI tool, therefore I'm declaring this dismissal void. However, in appeal, the Court of Appeal said, I'm just looking marginally at what this AI tool is doing. This person was warned 3 times, and there was a human in the loop. There was no defect in the AI program, so he was dismissed at the end. And that, I think that's an issue from an employment law perspective, but that is the status as is. We have also had some drivers in a logistics company, and they claimed that they were dismissed simply because the AI tool said that they did things they couldn't do. The court said, hey, that was not a fully automated decision, so there was a human in the loop. So the termination was okay by the court. However, based on the AI Act and the GDPR, the employer was obliged to show how the AI tool worked from a technical perspective. The other side around, an employee who used AI in his job and wasn't allowed to, led to a breach of trust, and that realized a disrupted working relationship and also a termination of employment contract. So AI can be used for termination in that perspective. But now, AI is over, and I'll give the floor to you, Nikki.
Thank you. Right. Yes, so over from AI, which is very new, we go to instant dismissal, which was always there, but it is always interesting because it's, if you look at case law, always juicy stories. And it's also, as an employer or as an HR team, you have to deal with it in a very careful way, and also follow all the strict conditions. And I'm just remembering the basics of the instant dismissal. But first I would like to know from you, do you apply something like 3 strikes and you're out, meaning that you give 3 warnings and then with the third warning, that automatically leads to an instant dismissal, also called, and it's also came across in the case law, like oei foei doei policy. And I'm looking now at the poll, and it's just yes and no for you. Right. So warnings, it's a good system maybe, but, like with the traders, for example, you don't know what kind of warning it is maybe. Is it the same thing? How do you have to weigh those warnings? Or can you say, okay, this incident is severe enough to lead to a instant dismissal?
In the Netherlands, I think that a lot of cantonal courts will say if you are being warned multiple times, that can easily create an instant dismissal.
Right.
And also zero tolerance policy, if that is put in writing, that is being seen as adequate warning.
Yeah. So I think we see also later in case law that, like, if you are warned, that have some importance, of course, but it's case by case. And now I see from the poll question, no one of you have a 3 strikes and you're out policy, which is, I think, good news. And you're following, you really look at it case by case. And of course, sometimes there need to be warnings and sometimes just not.
And maybe we forgot that the poll 1 and poll 2. Poll 1 was, do you use, let people use AI on the working floor? 100% says yes.
Yeah.
So that's clear. And do you let them use corporate accounts or don't you do that? So do you let them use private accounts? 40% let them use private accounts and 60% corporate accounts. So there is something which could do better in that perspective.
Yeah, let's review that once.
Yeah.
Right. Okay. So that's all the poll questions. Let's go over to the strict conditions of instant dismissal. And just good to remember, it's really a last resort, instant dismissal. We have a closed dismissal system. So as an employer, you can only terminate if you have this prior approval of the UWV or a court. And then you need always a valid ground. The valid ground, culpable conduct can be kind of similar for the urgent cause for instant dismissal. But as you see, you need all those conditions if you go to the UWV for a business, economic or organizational reason, or you need all arguments and substantiation for the other valid to show that you have a valid ground. And like instant dismissal is you need due process for it. You need to meet the strict conditions. But it's rather quick and cheap because you don't have to pay a termination, statutory transition payment. You don't need to take into account a notice period. It's just on the spot right away and you're out. And sometimes you can also claim kind of a compensation, fixed compensation from the employee. But that means that there are a lot of case law after an instant dismissal that the employee come back to or file an application to court to state, okay, this instant dismissal is not valid. So it's still risky business. But of course, we can guide you a little bit and to get your memory back on the strict conditions. And then in the Netherlands, instant dismissal is only legally valid if it meets the conditions. So there needs to be an urgent cause and also evidence of that, of course. And you need an immediate action which shows the urgency. And you have to inform the employee right away about the reasons, and then most likely in a dismissal letter. It's not obliged to submit to hand over a dismissal letter, but it's highly recommended because otherwise you cannot prove how you shared the reasons why you dismiss somebody on the spot. And to come to that conclusion that you want to get over to a instant dismissal, you make sure that you have a due diligence. So, is there any investigation? Was there some process? Did you hear them out? Usually. We have an investigation of a few days, and also to take into account all personal circumstances of somebody, and then you invite somebody for a meeting, and you hear them out, and then after that you take the decision whether or not you pursue with an instant dismissal. And why it's so risky? Because if the court may declare the dismissal is invalid, your employee is still employed, or the employee start a court case and he will get paid, and the instant dismissal is invalid, he get paid a transition payment, or in the worst case scenario, a fair compensation, and we don't know the amount of the fair compensation up front. I think the highest fair compensation given is up to $1 million. So that really depends on the facts and circumstances, and there's no formula. And you can also can be claimed a fixed compensation. That's the salary of the notice period that was not observed. And most importantly, if in some cases there's also a lapse of the non-compete. Some people forget about that, but that's possible in some situations. We have another poll question. We would also like you to know from you if you ever instantly dismissed an employee, yes or no.
We do that all the time.
We do that all the time. We're advising our clients whether to do it or not. And I think it's one of the reasons to get some support from lawyers.
I always say, one, be careful doing an instant dismissal because of all the reasons you just mentioned. On the other hand, if you are quite sure that something happens which shouldn't be done, at that stage you are the last one to know as being the manager or being the director. So also take into consideration what kind of effect does it have to the other employees if you do or do not fire someone on the spot. Because sometimes
it also has to do with precedent, of course, and if you're very principled or not. And in practice, what we also see is that you think, okay, this is sufficient for an instant dismissal, but we want to be kind of sure and don't want any court cases, or we don't want any information out there. That you opt for a settlement agreement, which is still an option, and also it's allowed. This instant dismissal is still like immediate if you have this second option. Okay, yeah, we will waive the instant dismissal if you sign the settlement agreement.
And we have the results of the poll question, and that means that 25% of everybody has experience with firing people on the spot, and 70% not.
Yeah.
So that's always exciting times if you need to send someone home.
Yeah, exciting times. Yeah, and you have to move quickly. Yeah. I will discuss some case law. The first one is about transgressive behavior. Here there was an employee in the gas station. There was a sales assistant. This person was on sick leave due to mental health issues. Reintegration started in September 24. And this person came back to the workplace, and there was some verbal conflict. There were some messages on WhatsApp sent to the manager and about a colleague, and this person, the employee, damaged also some mirrors from a car. And the same day after this incident, so it first started with the broken mirrors, and then after the messages, and then the same day of the messages, this person was dismissed for cause. So this was an instant dismissal. Of course, this person had some background with mental health issues, but at the same time, it was also there was no how do you say it? Issue that there was some anger issues or some prognosis that somebody couldn't work, but somebody else fit for work returned, and this conflict happened. Of course, this employee said, okay, but I have these mental health limitations, and I couldn't handle any conflicts, but the court didn't follow this. And there was some, all the abusive messages was seen as serious misconduct. There was also no sufficient medical evidence. There was his treatment. There was some treatment, but that was not that there was a really mental health limitation. And the employer already offered reasonable accommodations during the reintegration, and also still, and this incident was still work-related. So you have to show as an employer that you're very supportive. At the same time, there are some limits, and you cannot hide every time from your mental illness if there's a conflict in the workplace. If your doctor or your treatment takers cannot say, okay, this was due to your illness. So this kind of succeeds. And of course, in every case, like this case, the personal circumstances were also weighted here. But the misconduct outweighed them. Question? Okay. So this was valid, and they didn't. This person was dismissed on the spot, and they could also claim some fixed compensation, and they could offset it with the final settlement. And all the claims of an employee were rejected. So this was a successful instant dismissal case. Like the other ones, personal circumstances are taken into account in every case. And if you follow this due process and you were supportive during illness, but still some conduct cross the line, and then there are sufficient reasons to give an instant dismissal. Then I have another case on alcohol. Which is always a little bit tricky, because if there is an alcohol addiction, that can be seen as illness, and then you have this prohibition of termination. Also be very careful if alcohol is involved. As a result of being drunk, you can do stupid things. But this has also limitations. This case was successful. So this was a bank employee, and they had some alcohol issues in the past. And he admitted that he had some private problems. The employer, they offered some support, and also warned him, if this happens again, it could lead to a instant dismissal. There was also arranged some occupational health support, and they paid also for a psychological treatment of like an amount of 2,000. Also after that, and all the issues happened, and also the support happened, there were some other issues, some incidents. So they smelled the alcohol again, and he was late to work twice, and he failed to show up at work, and again he smelled at work in September. So that's two times in a row in 2 months. And then on the second day, they smelled alcohol again. They terminated with immediate effect, so there was an instant dismissal there. And this time the court thought this is sufficient. It was valid. This employee was explicitly warned. There was repeated misconduct. I don't know how they prove that this person smelled, how the alcohol was smelled, but that's also important. How can you test? Because there's also some privacy reasons. But as an employer, you have to act promptly and sufficiently, and they did that in this case. And they also had no proven track record of a alcohol addiction, which is sometimes difficult. So this employee acted with serious culpability. So there was also no entitlement to a transition payment. These two cases were very successful. And what I discussed before, why is it so risky to pursue a instant dismissal? There's of course that the employee within 2 months go to court and say, okay, my instant dismissal is invalid. That they claim transition payment, but the biggest risk is the fair compensation, because those amounts can be very high. This time it was about a employee with a kind of long track record since 2016, and there was a complaint from the workplace about this employee, and this employer imposed mandatory training on discrimination and safe workplace, and push for that he has to attend to this training. The employee disputed the allegations, refused the training, and reported a burnout. Then there was a conflict about the situation, and they tried a mediation. This mediation was unsuccessful, and then they at some point he refused to get back to work. And said, okay, I'm still ill. The employer suspended his salary. They issued a final warning, and ultimately a summary dismissal for refusing the training. Here the court said, okay, this is not allowed. You push for the training. There was a complaint, but there was actually a conflict between the employee and employer. They should prioritize the conflict first and then insist on the training. The problem here was also that there was a complaint, and then you push somebody for the training, but you should first focus where is this complaint coming from. Somebody is denying, and you cannot push only for the training. You should have to, as an employer, should solve the conflict first. So the employer was taken. Didn't pursue with this process very diligently, so to say, by the court, and the instant dismissal was invalid, and the compensation awarded in this case was a fair compensation of 250k as fair compensation, then a fixed compensation for not taking into account the notice period of 25k, and then also a transition payment of 27. So all in all, quite a big number of amounts, and I think you think maybe you have all the steps taken for due process, and this time it was not the case. And that is not the cheapest way out for termination. I have also another case. This time was also not successful, and there was also this fair compensation. It's kind of a recent case. This was also an employee with a long-term service, and there was some structural overwork for years, and it was also proven in this case. And there was the employee had posted a lot of signals for requests for support, adjustment, and the employer failed to respond to it adequately. And after sick leave, the employer and during sick leave, the employer continued to assign work and ignored delayed occupational physician's advice. And that was also included in mediation. So there was also kind of a conflict about the overload of work, and there was also a burnout situation. But also taking into account the personal circumstances, because this employee was also having an approved second job and also approved caretaker of family members. This was not taken into account for this instant dismissal. This person was dismissed because this was a finance employee working also in the HR department, having some HR task, and paid himself the overtime. And the unauthorized overtime payments lead to the instant dismissal. But the court findings were this is not an urgent cause. There was already some misconduct from the employer, and the employer acted in this case with serious culpability. And what they take into account is the years of structural overwork, the lack of adequate support and reintegration, the breach of good employer obligations, and the unfounded accusation of fraud. And the court decided that this instant dismissal was invalid. The employer ordered to pay the transitional compensation, and there was also a fair compensation at 2 times the transition payment. So again, this is very delicate. Maybe it feels simple, an instant dismissal, but what we take with us is to follow the strict conditions, but also take into account all the personal facts and circumstances, especially with this latest case. There was going on a lot, and it was also known by the employer, and you have to take it into account. So important to know. And then I want to give you some takeaways if you ever consider an instant dismissal, that you proceed quick and with due care. So in case you start any investigation, make sure that there's every day some progress. You cannot suspend an employee with payment and say, okay, we are busy with our investigation and it will take months and months. That cannot be the case. Make sure that every day something happens. If you decide to, in instant dismissal, come up with a well-written dismissal letter, we see in case law that sometimes not every reason is substantiated or given or motivated well, but the employee needs to know why he's dismissed on the spot. Be also careful with the use of criminal law terms. Sometimes there is theft, there is fraud, but just keep it to the facts, what you know, what you encountered and what you investigated. And if there's a criminal offense, then this should be lead to, of course, a criminal prosecution. And be aware that every possible evidence is secured. So sometimes you see something in the logins of the IT system, sometimes you have video images, and that can also help you, not maybe right now on the spot and for your investigation, but let's see if you pursue with this instant dismissal. You need it later on if this employee decides to take this up to court. I think this is the end of our presentations, and then I look if we have any questions. Not yet. Then there's still a webinar evaluation, and hopefully you can help us with that one. And other than that, I want to thank you for your for watching this webinar and for your attendance, and also submission of your poll questions. Thank you for your time. And if you have any questions about the subject of any other employment issues, please let us know. Contact details are here and you can find us.